Good morning, and welcome to the second argument on today's docket for the Kansas Court of Appeals. This is an unprecedented time, and of course that means that we have to be flexible, but our court continues to hear a full docket, and I'm proud of that. I also know that that makes it somewhat challenging for the parties and for the attorneys, and so I want to thank the attorneys for all of their work and preparation getting ready for today, and we're happy that we can still make this work. So at this time, it's my pleasure to introduce the members of today's panel. I indicated this in the first argument, but I want to say it again today because I think it's important. Next week is the 100th anniversary of the 19th Amendment to the United States Constitution, which guaranteed women the right of universal suffrage. And so I think that it's fitting that today we have a panel of all women judges who are hearing the case. The first member of the panel is Judge Melissa Taylor Standridge from Leawood. And Judge Standridge is the longest serving woman presently on our court. She's been on the court since 2008. And also with us is Judge Catherine Gardner from Topeka. Judge Gardner has served as a member of our court since 2014. My name is Sarah Warner. I'm today's presiding judge. I'm the newest member of the Court of Appeals, and I've been serving for just over a year, since 2019, and I'm from Lenexa. So with that, I'll call the second case on today's docket. That's case number 122147 in the matter of the marriage of John Thomas Lask and Catherine Ulrich Lask. Would the parties please state their appearances?
Good morning, Your Honors. Nicholas Shelton on behalf of appellant John Lask.
Good morning, Your Honors. Joseph Booth appears on behalf of Catherine Lask, the appellee.
Ms. Shelton, we have a 15-minute argument today. Would you like any time for rebuttal?
Yes, please. I'd like 3 minutes for rebuttal.
3 minutes is granted, and you may begin.
Thank you, Your Honors. It's a pleasure to appear before this panel today, and I appreciate your remarks, Judge Warner. This case is about the application of the child support guidelines, which requires this court to consider reversing $110,000 of a judgment of $129,000 because that $110,000 represented the special needs expenses, which are treated differently under the guidelines. And we brought this appeal because the trial court did not properly treat that portion, the $110,000 of the expenses, properly as required under the guidelines. That $110,000 represents the amount of money that the mother incurred for the out-of-state facilities for the middle child. That's the amount I'm carving out for this particular argument. In the child support guidelines, the structure of the guidelines is based on an economic model of average expenditures for an average family in Kansas. The three variables are the combined income of the families, the number of children, and the ages of the children. That is this background structure of the child support guidelines. The guidelines carve out treatment of expenses that fall outside of these ordinary expenses. And that's section E of the guidelines. If an expense falls within section E with that specific definition, then it must be treated differently according to the rules of the guidelines. In this particular case, we have one parent incurring, not an emergency expense, but incurring a tremendous amount of expense for the middle child during the year of 2015 through 2017 for out-of-state facilities for behavioral management issues. Mother
Ms.
did not.
Shelton, may I just have a question real quick before you get into your argument. I just want to know, what is our standard of review? I just want to get that down. Can you go over that?
I'd be happy to, Judge. The standard of review on application of the child support guidelines is as a matter of law. So you have unlimited review on how the child support guidelines are applied to this case. This is not a case where we're bringing a child support worksheet to you for a review on an abuse of discretion. This is rather an application of the guidelines, which is an unlimited review because it's a matter of law.
Okay, and then, but it looks like the district court judge found that the expenses were emergency expenses.
Well, if you look at his ruling, I don't know that he used the word emergency. I think it was clear that there was a need and that need needed to be met. It was not a type of an emergency room type of expense or that sort of thing. There was a need that the parents were trying to deal with. I don't think there was no testimony by mother that she couldn't have brought the matter to the court's attention while she was incurring the expense. In fact, if you look at the record, in December of 2015, rather than submitting any receipts to the father, she brought it forward as a motion for contempt, which would indicate at least that it wasn't an emergency from her standpoint. And so I don't think that the trial court viewed it as an emergency so much as a particular need in this family that arose between about 2015 through 2017. And I would point out also that the child had special needs throughout his life that began to escalate in 2015.
Counsel, wasn't there a previous order that had divided up medical expenses, uninsured medical expenses, proportionally between the parties? And did the court find that these were medical expenses?
The controlling order for the 2019 order came from a 2009 child support order. And in that journal entry, unreimbursed medical expenses were to be shared in proportion to line D2, but it was the language of the line D2 expenses. And this is kind of the issue here is, how do we treat what is a medical expense? Do we put it for sharing per income percentage under line D2, or is it a special need and treated under the section E of the adjustments? The 2009 order terminated what they used to have at that time, a shared expense plan. And the judge said in the transcript, we'll have no more sharing of tuition, no more sharing of expenses. Well, he was referring to the shared expense plan. And he said, but we will have sharing of the unreimbursed medical expenses. And if you look at the language, that's consistent with the language in the guidelines. The parents are supposed to share unreimbursed medical expenses, including any deductibles. So if we look at that, but look at the definition of special needs, which says that it is for expenses that exceed the ordinary and usual expenses of the children, then we can see the difference, even though both can be considered medical. A medical expense can fall under more than one category in the worksheet. So how do we figure out where to place it or how to treat it? Well, the guidelines give us the answer very easily. Under the special needs definition, again, it's for expenses that exceed the ordinary and usual expenses. And there's special treatment for special needs expenses under the worksheet as well. It requires the parent incurring that expense to file a motion with the court to bring it before the court for judicial review of whether the expense is reasonable and how it should be apportioned, which makes sense under the whole structure of the guidelines, which is a model based on average expenses. So in other words, what we're trying to say is the umbrella of the word medically necessary expenses, which is what the court used, is not the only analysis. Otherwise, that section E, special needs expense section, would be meaningless. It was never expected for all expenses to be shared in proportion to line D2 of the worksheet. In the Ronan case, which is kind of the only case that gives us any guidance, where they dealt with the application of the guidelines to an adjustment on the worksheet, the Court of Appeals in 2001 said that using statutory interpretation rules, the inclusion of one definition excludes it being somewhere elsewhere. So applied to this case, the inclusion of a specific definition of special needs, which it also says that includes ongoing therapy, ongoing health needs, and that sort of thing, then that means it is not to be included as a line D2 expense. Now, you mentioned, Judge Standridge, wasn't this an emergency? That was not dealt with at the court, but I think the case law teaches us and talks about where an emergency in the sense that the parent had to go out and incur the expense and didn't have time to come to court. And that would be the Ames case, where that was mentioned in that, well, it wasn't like that. And likewise here, there was no claim that these were emergencies. I mean, the mother got on a plane with the child and flew to these locations. It was not urgent. The need was there, but it was not, I have to get into the emergency room. I don't have time to take this to court. And remember, mother.
Counsel, go on
Oh,
ahead.
No, you're the presiding judge. You go ahead.
Well, counsel, I was just going to ask, wasn't all of this information presented to the district court, and the district court found that there, in many of these instances, there just wasn't feasibly time to go to court, that these were instances that needed to be dealt with immediately?
I don't think I agree with that. The court didn't analyze it in that context. The court said that, in fact, the mother delayed for 5 years between the time she began filing motions and the time we got to court.
But isn't that a different analysis? Asking for the reimbursement versus seeking the care, those are two different things, right?
Versus seeking the care?
Yes.
As compared to
asking for reimbursement for those expenses.
Well, and that's the whole crux of this, is if a parent goes out and incurs an expense like this, is it the question, the guidelines, I believe, requires is for a parent to file a motion and go to court. And if it is care for the child, is it you mean ongoing treatment, that sort of thing. In other words, as it's defined in the guidelines, does it exceed the ordinary and usual expense of the child? And I don't think there was any question that it met that definition. As far as whether it was an emergency, that was not a question that was raised in the court. When the court was analyzing these expenses, if you look at the language of the colloquy at the end of the hearing, he talked about there was a need, and the need needed to be met, but not in the sense of an urgent, other than the sense that when a child has a need,
okay, let's
need as quickly as possible. But whether that's an emergency is a different issue. Like, there's no time to go to court. I don't think the court found that there was no time for mother to go to court. I frankly don't think the court understood. I didn't make my argument very clear to the court regarding.
Okay, Ms. Shelton, I have a question. You know, I did a summary, like a chronology, and of these expenses, and it looks like from June 1st to December 16th, 2015, when she filed that motion for contempt because he wouldn't pay his half or his 89%. In that June, July, August, September, October, November, so 6.5 months, she incurred $96,000 in uninsured medical on behalf of the middle son in 6 months. And he was in 1, 2, 3, 4, 5, 6, 7 different facilities in that 6 months. And the reason he had to, on at least 2 occasions, the reason she had to switch is because the middle child had engaged in criminal conduct, and the court would be willing to dismiss the charges if they found a placement for him within 24 to 48 hours. Now, based on that, it appears the district court found, based on those facts, that her being a mother to 3 children, and this is the middle child, and she's flying all over to try to take care of this every time he does something, that she didn't have time to take a breath and file something, but did so within 6 months of incurring these expenses. So would you not say that this was, I don't understand your argument.
Well, keep in mind that mother filed a motion for contempt in December of 2015, and in that affidavit, she brings up 2 sets of expenses, so to speak.
Right.
One, medicals, and the other is the $96,000 for these facilities. And mother admits that she never presented father with any request for reimbursement. So it's a motion for contempt that's brought before the court.
No, she didn't. No, well, actually, there's evidence in there that she, let's see, in June of 2015, when all this starts happening, she emails the paperwork and the receipts asking for reimbursement, and husband says, I've already contacted your lawyer. You're going to have to work with your lawyer. I'm not going to talk to you about this. And then then she goes and hires an accountant for $5,000, and he organizes everything. And then she sends him that information in a much more organized fashion, and he refuses to respond. And then in 2015, after she sends that, she presents him with 3 different options for PRTFs, I call them, psychiatric residential treatment facilities. And he says the only thing that will save his son is military school. And then that's when she starts this 6.5 months, keeping him informed. He knew every single time, that of these changes in facilities. There's no dispute in the evidence that he was kept informed every single time when these facilities were changed. There was one time that he wanted to go to Florida to build a boat, but it wasn't a locked facility. So I still don't, I read the whole record. Based on all these facts, I really don't understand. I would say that the record doesn't support your position that she didn't ask. Her $96,000 was incurred starting on June 1st. And that's in June is when she started mailing him the paperwork and receipts asking for reimbursement.
So just to clarify a couple things, in June of 2015, she presented a spreadsheet, not receipts. And if you recall the judge's ruling at the very end, how can I hold him in contempt when she never presented this to him? So it wasn't receipts and things like that. I don't want to quibble, but it was a spreadsheet. And it took the special master, if you look at the report, it took him 2 years to sort through all the paperwork. But be that as it may, I want to get to your point, which is, you're right that he knew that, but keep in mind that when we deal with these expenses, what does the child support guidelines require a parent to do when there is an expense? We have the regular co-pays, deductibles, and things like that are predictable and expected in a case. And And we agreed at the trial there were line D2 expenses to be shared if they weren't barred by the latches. And here we're dealing with what we're dealing with is an expense that is over and above what is average and ordinary. These out-of-state facilities, the fact that he was facing criminal charges, does that constitute an emergency? I mean, that's a question for you to decide. My position is no. The fact that he was in trouble criminally and it was a solution to the criminal problems met a need. But does that mean that the rules require under the special needs where a parent the onus is on the parent incurring the expense to have a judicial review of the special needs? If it becomes a special needs expense, our position is that it is a material change of circumstance. And at that point,
Counsel, I hate to cut you off, but I've allowed you to go over your time a little bit. I'll let you finish up your thought, but then if there are no other questions at this time.
We do have some more questions.
Right.
I'm sorry.
Right. It's fine.
Okay, so I have a question about special needs. He was aware that his child was special needs, correct? He had an IEP or a 504 or something at school, correct?
That's correct.
Okay. And would you agree that his special needs was the trigger for his criminal behavior? I mean, you're trying to separate out the criminal behavior.
I think that it's when a child is special needs that those children end up more likely to commit crime.
Just like adults, you know. So anything that she had to go to, you know, I mean, that kind of is an amorphous kind of blurry line. Okay, and if it was special needs, and you have to, if we do accept your argument that it's special needs, and that she had to file a motion to what motion would she have had to file? I'm trying to look up the guidelines, but
sure. If you look at Section E, it gives specific rules regarding the burden of the person, the custodial parent who wants the other parent to pay a special needs expense. And the rules require very plainly, the parent must file a written motion before the hearing, and the burden is on that parent to show this is a special need. We need to treat it outside the normal ordinary expense. It's not an ordinary expense. It's outside the guidelines. And it's up to the court after a judicial review to determine whether it's a reasonable expense and in the best interest of the child. So we didn't have that here, but the rule.
Let me ask a question. Does that section of the guidelines say whether that hearing has to happen before or after the expense is incurred?
The case law, the Ames case and the Ronan case seem to indicate that it is expected that the motion be brought either before or while it's being incurred, which indicates a level of timeliness on the parent who's asking the other parent to pay the expense.
But a plain reading of the guidelines, there's no timing.
Well, it says that as far as the burden is on the parent to file the motion before the hearing, and that would indicate that it would be expected to have the expense, or at least have an idea of what that expense is in advance.
Well, wouldn't you say that in this case there was a hearing? That your client got plenty of due process as contemplated by the child support guidelines under the special needs?
Well, if you notice the January 2019 journal entry for child support, that was mom's opportunity to bring up the special needs, and there was a discussion about that. So in terms of and that judgment was not appealed. We're appealing a judgment where my client did not have a due process or a judicial review of this expense. And keep in mind that mother had extra money from the trust, or in theory, for expenses like this. But no, he did not have that. It was after.
So it's your position that if we remanded this for a special needs hearing, I mean, would you be satisfied if we remanded it for a special needs hearing?
Actually, yeah, that's my relief, that I'm asking that the court find that these expenses of $110,000 are special needs expenses. And what
difference would that make to the relief?
Well, if the analysis would be, it would make a big difference, because if it fell under the category of exceeding ordinary and normal expenses based on an average family, which is what the guidelines are built on, then that would, if mother didn't bring her motion and she, the child support's already been determined, then those would be eliminated from the judgment, because it would be an
So the special needs motion, that is a modification of child support?
Absolutely, yes. That is a material
So
change.
it's not expenses, it's not specific expenses, it's a modification of ongoing child support.
Right.
So she would have wanted, so if her, if her child, their child had needed to stay in a PRTF for 6 months and then came out, then she would have no need for those special expenses anymore.
Well, I think the question is how to apportion that. How do you treat an expense that isn't considered in the basic computation? And in this particular case, if you look at the language of the guidelines, the intent, and the economic model that it's based on, it's all based on average and usual expenses, except for the section E.
Okay, now I understand.
Okay, sorry.
I did not know. That's my fault. I did not understand. So special needs is not based on expenses. That's a child support modification that goes on forever until age of majority.
Exactly, and that's based on the nature of the expense. I'm saying to you that we don't treat, yes, it's not based. We can't just say everything is medically necessary, because, like in my brief, I say that could be everything. It really is. When you have an unusual and extraordinary expense, it is a material change of circumstance. The onus is on the parent.
Okay.
Okay.
I got it now. Thank you so much. And presiding judge, Judge Warner, thank you for allowing me. That really cleared it up.
Thank you. Ms. Shelton, since those questions went past your time, I'll still give you 3 minutes, but I'm going to allow your opposing counsel equal time, obviously. Thank you.
Thank you.
Mr. Booth, you have 20 minutes.
Thank you, Your Honor. One of the reasons why the rationale in this argument is not making sense is because it's a case of Ipsit Dixit. And what I mean by that is we've created a unique analysis under one of the deviations from the child support guidelines. Child support guidelines create a presumptive amount of support based upon the incomes of the parties. And then there are deviations in that latter section of the worksheet that allows the court to make other changes, including things like allowances for tax considerations and all of those. The special needs arises as a deviation from the support when those are routine, regular expenses, and the language in the guidelines states special needs of the child are items which exceed the usual and ordinary expenses incurred, such as ongoing treatment for health problems, orthodontist care, special education, therapy costs, which are not considered elsewhere in the support order or in contemplations on the worksheet. The amount of the special needs expenses reduced to a monthly average should be entered on line E3, special needs. So there's no such thing as a special needs hearing. What the order that was in place contemplated was there was the regular child support was represented by the child support worksheet and reduced to a monetary monthly award. The unreimbursed health care expenses were handled by a different portion of that order, and that's where you get the 11 and 89%. And that is for whatever is a unreimbursed health need. And it is not based upon an emergency. It's not based upon anything else. In this situation, Dr. Lask had put himself in a position where he had lost decision-making custody over the health care of his children. And Mrs. Lask was placed in the position of being solely responsible for those decisions. And as Judge Standridge noticed, this was a mom who got hit with an onslaught of a child in great suffering, and it just one thing after another, including tragic things that are mentioned in the facts about what happened to this child when some of those institutions didn't treat him quite appropriately. One institution, as he ran away, sent dogs after him. This is a painful story. But when we go back and look at it under a child support question and that dry environment of just legal analysis, our child support guidelines contemplate that we're going to have these unexpected and out of the ordinary expenses that are not covered by insurance and are not otherwise reimbursed. And each parent's moral and financial obligation is represented by that unreimbursed healthcare expenses, which means it's a broader category than just medical. So when we have a structure in the guidelines that do that, this is exactly what would be happening as we move along. And the safeguard is not the special needs in the category of trying to create and predict what's going to happen in your various children's lives and what it's going to cost. The safeguard is in if there's a challenge between the parents on whether or not this is an applicable charge. The first category of thought for the court is whether or not it is a need, and if it was a luxury. I've had hearings that involved requests for plastic surgery, and the question of whether or not plastic surgery for a child is a need or a luxury. If it's a need, then it fits the first standard, and then the court enforces it. And anytime we have our district court enforcing these various obligations, it has to be not arbitrary, not fanciful. It fits under the standard of the judge's discretion. So you would have situations where there was a need, an expense incurred, but the court may not enforce the full obligation on one party or another for other reasons. But the structure and the idea that we're going to have a special needs hearing or somehow use the special needs category, which is a narrow exception or deviation from the presumptive guidelines, is completely wrong. It isn't within the structure of how the guidelines are created. And it isn't within the structure of how to work with this. What that unreimbursed medical expense category does do is it fits into anticipatory and retrospective expenses that happen that may be variable by a significant degree. For example, we usually know with orthodonture what it's going to cost us per month for the next several years of payments. But we don't know in other treatments, such as the childhood diabetes or something. Those come up and it's intended to capture the variables of what is going on. And so instead of it being a retrospective child support award, it is a prospective proportionate allocation of variable expenses that come with children. And if you have children, the one thing you can expect is the unexpected when it comes to expenses. And so that category works that way. This is simply a matter of working backwards. If you look at the timeline of the case, these arguments didn't even arrive until late in the litigation, after we have Dr. Lask turning around and trying to file his motion to show cause after the third time the special master came up with a fairly sizable award that was intermixed with several arguments for the parties. And as Judge Standridge pointed out, the litigation about many of these things began when Mrs. Lask realized that she was in crisis with her son. That period of time in which almost $100,000 was spent, almost just like opening the tabs. And it was to save this child's life. And whether each step of the way worked out well or not, they were well-considered decisions. And as Judge Standridge pointed out, Mrs. Lask kept Dr. Lask informed, even though she had sole decision-making authority over this situation. She fulfilled her responsibility and her moral duty to let that happen. It's just that he didn't expect to have to pay. He has a very large child support obligation, and it appears that what he felt like was that I've been paying enough money. You get over $100,000 or almost $100,000 a year in child support. That's what that's for. And it's not. The monthly payment for child support is for a child during their minority, in this case, 3 children, during their minority to care for their needs, not for later, and it's not to care for their unreimbursed healthcare expenses. That is not what child support's for, because we have that second obligation that we're required to put in every child support order to mandate that allocation. So as this thing gets flipped on its head logically, you wind up with somebody insisting, and this is what Dr. Lask's position is, that when trouble began to brew, Mrs. Lask was supposed to, one, stop taking care of her child, go to court, two, in doing so, ask for regularly monthly payments to predict an expense that probably all the way to the last one she never knew was going to come. It would be unimaginable for anybody who has gone through this kind of experience with a child to anticipate that the first thing you tried to do to help the child wasn't going to work. You know, it comes one after another after another, and it was a very difficult time. But to overlay that with an expectation that you're supposed to somehow go to the court and get permission would put the court in a position of actually also litigating and micromanaging the medical expense, the medical treatment of the child, and the other health care decisions across the board. And that if she would have started litigating this issue at the time that she figured out Nick was starting to get sick, she probably wouldn't even have been on the docket until after Nick went through that dark time. The courts aren't responsive and able to handle those sorts of situations at all.
Counsel,
Yes.
if this were a special need, could you step the court through what that would look like process-wise in terms of what Ms. Lask would have needed to have done in order to go and get that reevaluated?
Right. Let me start by answering your question first with a refresher of what the special need situation is. And the special need can be for a good thing or a bad thing. It could be for other expenses that relate to education and other items. Professor Elrod sets that out in her treatise. And it is a adjustment to the presumptive amount of child support found on the worksheet. You get down into that category box F, and you have the various deviations. And the court could hear evidence and find that there were, the best example I could think of at the top of my head would be something like orthodontia. We know we're going to pay $200 a month for the next 2 or 3 years for little Susie's orthodontia, or we're going to have these lessons that are additional tutoring to help a child who's either gifted or delayed. Those are the sorts of things that you can put in there. One of the biggest reasons why the special need category is in there for a deviation from the presumptive amount is many of these child support worksheets are dealing with trying to get the services and the child's needs addressed, and there may not be any communication between the parents. So if it's predictable and you know you're going to get it, you could put that special need category in there and ask for it to happen. It is not for unanticipated medical expenses. It is not for anticipated medical expenses for which there would be an unknown cost. So things like the routine care with the pediatrician that's going to happen over the next 3 or 4 years does not fit into special needs. It fits into the allocation of unreimbursed medical expenses because there's so many variables. We don't know what
if there were a special need, I'm sorry, counsel, if there were one of these special needs that arose, then the parent who was requesting an adjustment would go to the court and provide that information and request an adjustment just by way of motion?
Again, it's a deviation. It's heard during the establishment of a child support order. So there is a logical fallacy here in the idea of if a special need arises. It isn't that a child has something special that they need that the adjustment is for. The adjustment is that there are ongoing predictable costs for which the court can adjust the presumed amount of child support to cover that regularly occurring cost.
And so if something arose, someone could say, file a motion to modify child support in light of the need for Susie's
Well, if there's a
Great.
material change in
Right.
circumstances.
Right.
So,
Yeah.
for example, if your child, if your child, let's say, can't, is going to be, I guess you're using an example of, because of behavioral issues that are related to medical, they have to go to a private school. And then that's going to be all of high school. Then is that a material change of circumstance? Mr. Booth?
No, not necessarily, because but I like your scenario, and the reason for it not necessarily fits well with your dovetail with your scenario. On the one hand, if it was to be considered an unreimbursed medical expense or unreimbursed healthcare expense, the person who's paying that bill may not be confident that everybody's going to agree with them on that, because it's private school that was instigated for the purpose of dealing with a medical issue. And so they may be inclined to go and seek an order allocating those expenses after they figured that after they found that their co-parent won't do that, won't voluntarily tee up what the expense would be. And that would be a circumstance where you may be seeking an order, and it could be in a modification of the child support, or it could be another order relating to, in the species of child support, where you have your standard child support amount, then you have this order that relates to this unique issue, and then you have the order. But logically, we don't have, there's no need that's special in a different category than that it wasn't already labeled. And that label for all these things is the unreimbursed healthcare expenses. So if the expense falls under that category, we already have an order that deals with it, and you don't need to modify the order because it is flexible and it depicts, based upon the income of the parties, exactly what they're supposed to pay.
It seems like that, just based on both your arguments, that it turns on whether there's variables. Like, for example, what you're saying about orthodontia, okay? You know that's going to last for 4 years. You know it's going to be a certain amount a month for 4 years. But if you have a situation like your kid is, in and out of Marillac or KDC, or Sherwood or whatever it's called, you don't know what the discharge plan is going to be from day to day. You don't know, so, whether something's predictable or not. Is that right or not?
In a broad brush, yes, but the following is very important. In neither case does the parent who does not want to pay get out of taking care of their child. So if you have a
right,
situation,
I'm just saying whether or not one is you seek as an unreimbursed medical expense versus one is you go and try to modify the child support.
Yeah, if you know that you're going to incur an extra, let's just call it $200 a month for something that one of the children needs, then you can ask the court to apportion that cost and go ahead and just have it paid through child support, because it's such a customary and routine. But that is a discretionary adjustment to the child support that is a totally independent variable. Right. What the appellant seems to be saying is you don't owe anything if somebody didn't put it into the special needs. For some reason, special needs eclipse unreimbursed health expenses, when unreimbursed health expenses are their own category of an obligation a parent has to care for their child. And that goes forward regardless of what it is. People may not want to put that special needs adjustment into child support because the obligor may be saying, well, it could go way down in cost, or it could go way up. And the obligee has the obvious concern that they've already relegated and liquidated that claim down to whatever it was on the child support worksheet. And then if things go crazy, we find problems in your orthodontia order of treatment or whatever it is, you still don't escape your moral and legal obligation to take care of those needs for your children. And they're based on needs first and then the court's discretion second. There is, if there's a hearing, it's a hearing for enforcement, not for to create the obligation. And the appellant here is trying to say that you have to have a hearing in order to obligate Dr. Lask to take care of his children, instead of figure out exactly what his liability would be if he objects to paying his line D2 proportionate share of the unreimbursed healthcare expenses. And those are very, very different things. And by analyzing it in the upside down way, you wind up with a way out of the proverbial box of obligations for this child. And it's not the right way to do it.
Counsel, the categorization there in terms of what the court categorizes these expenses as, whether they're categorized as unreimbursed medical expenses or other, is that a legal decision? Is it a factual decision? Is it a discretionary call by the court?
Imagine a Venn diagram. The court must make orders to distribute unreimbursed healthcare expenses. That is just that standard order that's set out within the guidelines. And now it even has a call and response. You have to request reimbursement, and then they have so much time to make the reimbursement. That's one category. That imagine the Venn diagram now being just slightly off center in the special needs of this narrow adjustment to future child support that may be medical or may be some other special need that a child has. And again, in the special needs category, I have seen adjustments because the child is gifted. In other words, you're not trying to pull yourself up into a level of normalcy. You're answering the call that the child has certain gifts. I've seen it being used for all kinds of different little categories that people put in there for that. But the guidelines again refer to it as they exceed the usual and ordinary expenses incurred, such as ongoing treatment for health problems, orthodontist care, special education, or therapy costs, which were not considered elsewhere in the support order. And here, all unreimbursed healthcare expenses are considered elsewhere in the support order. So the special needs category is simply a deviation from the presumptive amount in the child support, and not some creation of an obligation to pay for something that you wouldn't otherwise pay for.
My question was a little bit different though, and that is, okay, in the court's order here, in finding that these expenses were unreimbursed healthcare expenses, that conclusion, is that something that's a factual finding? Is it a just kind of, I have discretion to put these somewhere and this is where I'm going to put them, or is it a legal determination by the court?
Okay, it is a legal determination by the court that the proffered request for reimbursement is within the category of unreimbursed healthcare expenses. And here the court, and then that's reviewable by an abuse of discretion standard, which is where I think I'm trying to parse that out to get to the meat and potatoes of your question. So the court holds a hearing and you have travel associated with the need to take care of this child. That would be an unreimbursed. But if somebody wants to appropriate some portion of their monthly car payment, the court may say, no, that is not an unreimbursed medical expense. You had that expense anyway. You know, I might give you some allowance for the expenses for that particular trip, but I'm not going to make them pay for part of your car payment.
So that's a discretionary call by the court in terms of where you're going to draw the line, essentially.
Yes. And here, what Judge O'Grady did was look through those expenses, why they were incurred. I realize that there are complaints about several menial type expenses, including the travel that was necessary in this situation. But he found that the travel was necessitated for solely the purpose of taking care of this kid's healthcare needs. And I do think it's important to continually repeat how this is not a a unique, catastrophic, or emergent kind of category of an obligation. It is a broad category anticipated that we're going to have unreimbursed health care expenses if the child needs it. And that's what that category is all about. And we're required to put that in every child support order and apportion those costs. So, you know, we're not talking about the child support guidelines and how to build the monthly obligation here. We're talking about that other part of child support, which is to answer the call for these various expenses that are not part of the day-to-day, in this case, literally meat and potatoes for the child.
Mr. Booth, let me switch gears a little bit. Could you address the latches issue, please?
Certainly. First, Judge O'Grady found that she was relatively prompt in coming to her request. And as Judge Standridge indicated, she did try to reach out directly to Dr. Lask as this process was going on and kept him informed, et cetera. But in addition to that, case law, and I can't think of the name of the case, it is in my brief and was in the decision, finds that lashes are not an appropriate equitable consideration when we're dealing with child support obligations and reimbursement. We can have other layers that keep the conversation contemporary, and the new child support guidelines do. There's a waiver application, which is a different legal theory, that if you don't present your co-parent with prompt requests for reimbursement and the appropriate documentation, you lose the right. And though that language has been a part of my standard child support orders and agreements all along, but lashes is not an appropriate remedy. It's also not an appropriate remedy in this case because that was not brought up as an affirmative defense. It was brought up in the briefings as we in the latter start part of the argument and before the district court and brought up here. But they did not, that was not an affirmative defense laid out when she originally, when the contempt action came forward. His response was, I don't owe you anything because I might have been able to use my other insurance that I have, secondary insurance, to address some of these costs, but he never provided the court with any sort of facts about that or evidence to support that claim. He just hypothesized that secondary insurance might have covered that. And I don't know of any secondary insurance that's going to cover the kinds of expenses that Nate had over that summer. That is the largest body of those expenses. Does that answer your question?
Yes, thank you.
Council, I think that we're coming to the end of our extended time, but panel, are there any other questions? All right, Council, I'll give you 30 seconds to wrap up, and then we'll turn back to your opposing counsel.
Thank you. We all have obligations for our children that are unanticipated and unexpected, and we all have the obligation to answer that call. And there is no way in which one person is going to have the responsibilities placed upon them to choose to answer the call of parenting and stand alone, then to turn around and predict what those costs are going to be. If they can't find an agreement with an unwilling parent, seek court enforcement, all contemporaneously with trying to answer the cries of a child. It's just simply logically and morally repugnant to set that kind of standard forward in a case like this.
Ms. Shelton, you have 3 minutes for rebuttal.
Thank you. I want to hit on a couple points quickly. One is that Mr. Booth indicated that mother wasn't able to really litigate this issue until after the fact, kind of summarizing there. I point out the record reflects that after mother submitted her spreadsheet for reimbursement in June of 2015, we filed a motion to compel Mother responded and engaged in that litigation. And even in that, her response, she described the therapeutic schools as a reference to the educational component. So she responded in the litigation, but chose not to raise the issue in a motion to modify. Which brings me to another point, which is I disagree with you, Mr. Booth, regarding that the special needs category can be used for lessons and things like that. If this court will look at the Ronan case, the analysis in that case, Judge Eisenhower in Johnson County put extracurricular activity costs as a special need, and the appellate court said no, because that's an ordinary and usual expense. It doesn't belong in the special needs category. We have the reverse here, where we say the usual and ordinary expenses should be shared in line D2. But the extraordinary, those that exceed, like in the Ronan case, that is only reserved for expenses that exceed the usual and ordinary, which I think should be the point of a special needs hearing. Did mom's request for these expenses, what fell in under the definition of the guidelines, special needs, and what was the usual and ordinary? We're requesting the court to order that any expense that falls under special needs from the court's perspective, the district court, that be considered a representative of a material change of circumstance constituting a modification of child support, which is impermissible. That's what we're asking you to do on this for relief, is to remand to the trial court, hold a hearing and determine what should have fell under the definition of the guidelines in the Ronan case and the other cases, if we can, as expenses exceeding the normal and usual. And those should be eliminated and carved out of the judgment, leaving only what I would call true medicals. Under line D2, if we talk about predictability, it is really reserved for the things that we know about, co-pays, not ongoing orthodontia work, but just the usual things that we expect, deductibles, co-pays, and that sort of thing. I want to make one more quick point, and that is that even though mother had sole decision-making authority for health decision, it doesn't mean she has the sole authority to bind the other parent to a financial decision that he disagreed with. Dad wanted to help. He had different ideas about what would meet the need of the child. And you can see that ultimately, when they reached an agreement, he did pay 50%, even though he was funding the trust the entire time, and he felt like he thought mother was actually spending money out of the trust that was for those type of unusual expenses. So I don't think we should fault Dad as if he didn't want to pay. He's been throughout, because of mother squandering the trust, father had to pick up over $100,000 in college expenses for the oldest child during this entire time, which I would point out to the court that these figures can offset each other. If you carve out $110,000 from the $129,000 judgment, it leaves $19,000. Mom actually owes Dad for her share of his college expenses of $29,000. So there's going to be, ultimately what we're seeking is an offset. And if the court would consider in the trust account issues, we're not asking for a judgment against mother, but we are asking that the court take in consideration the unaccounted for trust money, and that be a credit against if father ends up at net owing mom. It would be unjust for mom not to have to account for the money in the trust because she was the one responsible for that. Are there any questions? Otherwise, I think I've reached the end of my time.
All right, seeing none, I want to thank counsel for your arguments today, for your time preparing. This court will take the matter under advisement. We'll conference the case and issue a decision just as soon as we can. And this concludes today's morning arguments. Thank you.